Hi, this is Ed Sullivan and Mark Oberti with our video podcast series. Mark, we're talking about employment agreements, and a lot of times an executive employment agreement will have a very pro-executive clause in there called a notice and cure provision. Could you explain exactly what that is and why it's important in executive litigation?
Absolutely. And from time to time, we've had corporate clients call, and they're having problems with an executive, and oftentimes if executives butt heads, well, the executive on the lower rung of the ladder, they want them gone pretty quick. But if there's a notice and cure provision, what that essentially says is if the company has a problem with the executive and believes that the problem is so significant that their malperformance, poor performance, or misperformance is so egregious that they should be terminated for just cause, the notice and cure provision says, as the name suggests, that before you can pull the trigger at the company, you have to give that executive written notice of what the alleged deficiency is in their performance and an opportunity to cure. Usually there's a deadline for that, typically 30 days. And so companies don't like to comply with them, and you can imagine why, because when they're ready to let the person go, they're ready to let them go oftentimes. Whereas executives, this is a very powerful prophylactic, protective shield, and oftentimes a weapon, because once companies realize this exists, oftentimes they do not want to go through the notice and cure provision and all the time and effort that takes, which leads to a negotiation regarding severance. So if you're an executive out there negotiating an employment agreement, you really want a robust notice and cure provision.